You will have had everything we have to offer at that point. If I send you to safety, we will have spent probably over $100,000 on you individually for this help. Good morning. Are you Ephraim Dinkin?
Yes, ma'am.
And this is cause number 19-32080. And Mr. Dinkin was previously in court, entered pleas of true, and a motion to adjudicate pled true to counts 1 through 5. And the agreement was for a cap of 10 years. I've received the updated report from probation. Have you both had an opportunity to review that report?
Yeah, they have judges.
Any additions or corrections? All
No, not from the state.
right, then you may proceed, Mr. Lewis.
Judge, as far as this situation, Mr. Dinkin, with Mr. Dinkins, we know it's a big ask. He is asking that the court consider keeping him on probation, maybe amending his conditions.
Well, first of all, I can't continue him
Okay.
because his probation expired in 2024. So the only option would be to revoke him, sentence him to time on a straight probation. That's the only option other than regular time.
Well, let me rephrase that, Judge.
Okay.
We understand that, okay, even if he is the conviction, he does take the conviction and he goes to a straight probation. What Mr. Dinkins is asking for is the opportunity to get the help through probation that's available to him. He know he is messed up, and there's times that he hasn't in the past taken taking those opportunities that was available to him. He's more than willing to try to do that for us, the anger management and the things of that nature. He's trying to better himself. He's a lot older now, to where he can kind of really realize where he is in life and what he wants to do with himself going forward. He knows that probation can help him. He understands that, if given that opportunity, it would probably be only one opportunity and it'd be a zero tolerance type situation. And that's what he's asking for, Judge.
All right. Thank you, Mr. Lewis. Mr. Smith?
Judge, I would disagree. I think revocation, he had a chance at probation. He absconded. He did nothing. We have no idea what he had been doing for that time. And so I feel like PDC time is appropriate in this case. He was given a chance by his own choices. He believed that.
So, Mr. Dinkin, Mr. Smith went a little light on the chances that you've been given. Because when you were placed on probation back in 2019, started off decent, and then it looks like in 2022, and you were 39 years old in 2019, so it's not like you were young and you've learned something and, you were a kid when this started. You started testing positive for cocaine back in 2022. You were referred to the ATAR substance abuse program, did not comply with all of those directions. So you were given help. Then another administrative hearing was had September of 2022. You tested positive again for cocaine. Even though you had previously been given that opportunity to go through the ATAR program, you had made no effort to enroll in it. So number one, there aren't any other things to do. You will have had everything we have to offer at that point. If I send you to safety, we will have spent probably over $100,000 on you individually for this help. Do you understand the opportunity? And I don't want you to go take this bed from someone else and not take advantage of it, because that's what you've done so far. I got a memo, I'm sure, that said to send you to ISF, which I did. And you went through both tracks of ISF, the cognitive and the substance abuse track. And the end of 2022, you got out 2023. You started testing positive for alcohol within a month of getting out of ISF. And you were then referred to the DROP program to help you, even though you had just gotten out of ISF, and you never showed up and you've been gone ever since. So I don't know what other options or, things we could do for you. You've been given every opportunity to have whatever treatment you need to be able to stay out, take care of your family, as you say. But that's not what you've been doing. So, I mean, you've been gone since 2023. Anyway, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon to a family member. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess. Good morning, sir. Are you Jeremiah Douglas?
Yes.
And will your client waive the formal reading of the indictment in each case?
Yes, please, Your Honor.
Mr. Douglas, in cause number 25, DCCR 1115, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from July 27th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? And then in cause number 25 DCCR 1222, you're charged with a second-degree felony offense of fraudulent use or possession of identifying information between 10 and 50 items, and that's from July 27th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes.
And because you actually did what they charged you with? In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. West?
Yes.
Do you fully understand them? And do you understand, if I follow the agreements that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? And so it looks like the agreement in 1115 is for a 5-year deferred probation, a $500 fine, and any other conditions subject to the pre-sentence report. Is that
Yeah,
correct?
fully right, yeah.
That was primarily to entail a forfeiture in the UCW misdemeanor.
Okay. So as part of these plea agreements, that he's going to take care of the unlawful carrying a weapon and forfeit that. Is that correct? Is that your understanding as well? And then in cause number 1222, it's the same agreement, which is for a 5-year deferred probation, a $500 fine, and obviously the same conditions of probation, and also that you would take care of that unlawful carrying a weapon and forfeit that weapon. Is that your understanding? Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up, please.
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Douglas is not competent?
No, ma'am, not at all.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. You need to stop on your way out of the courtroom today to talk to probation, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Yeah, I need
I'll send that to you.
Don't sign it. You have to
Yeah, yeah.
sign his right now. This is Mr. Smith sentencing.
Sorry.
It's John Jackson.
Absolutely.
All right, sir, are you John Jackson?
Yes, Your Honor.
This is 24 DCCR 1968. Mr. Jackson was previously in court, entered a plea of guilty to aggravated assault with a deadly weapon. I've received the pre-sentence report. Have you both had an opportunity to review the report?
Have Judge.
Yep, Judge. Sorry, I have all the Christmas files organized. I can just grab it real quick because he had a couple things happen.
Okay.
We have one called clerical correction, Judge.
I'll defer to Mr. Gertz first, Judge.
Go ahead.
On page 3, under monthly expenses, when Mr. Jackson filled out the monthly expense amount, he inadvertently left off taxes that he has to pay. And so he would say his expenses are $983 for whatever that means.
All right.
We have no other corrections, objections, or changes.
Thank you.
And we're
Let's
asking
not be
you to
no-
follow the agreement.
Thank you, Mr. Brooks.
Judge, I'm obviously aware of the case after review of the PSI and in discussion multiple times with Mr. Smith about it. And I believe the concern the state would have would be the comments made in the defendant's version. But we'll defer to the court with whatever you deem is appropriate for final resolution.
So it gave me some current concern also, Mr. Jackson, about the level of responsibility that you are taking about what happened that day. Obviously, you understand that what happened that day is not how you handle any type of situation like that. Do you understand? All right, sir. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney, defer all proceedings, place you on probation for 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. One of those is that you are not allowed to possess a firearm at all. Do you understand? That's in your home. No one else can have one. No access to any firearms. You understand?
Yes, Your Honor.
Also, there's going to be a mental health evaluation just to see if there's any issues that need to be taken care of while you're on probation so that they can give you whatever help you need to be successful. If you do everything that you're supposed to while you're on this probation, it's a great opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to prison for anywhere between 2 years and up to 20 years. Do you understand?
Yes, Your Honor.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up when she's ready to go over your paperwork. Good morning, you're Miracle Oville. Ms. Oville, did you get someone hired? You didn't?
No.
Who'd you talk to? Speak up, I can't hear you. You didn't speak up. Talk louder. Who? Dunham and Jones, okay. Who else?
I can't remember. I just have to take this in.
I can't understand.
Watch what's happening here. The judge isn't just asking for names. She's testing whether the defendant followed the court's instructions and came prepared. In court, organization matters. When someone shows up without clear answers, it can raise concerns about how seriously they're taking the process.
The other guy, I can't remember. I can't remember.
Mr. Parker, can y'all hold it down? I'm having a hard time hearing.
So the other guy, I can't remember. I just have a text message from. I don't remember his name. I didn't speak with him. We kind of went through like.
Why didn't you, so you've been here before, why didn't you write all that down and bring it to me like I asked you to?
I did, but I had it in my phone. I didn't transfer it to paper. I hadn't had it.
Well, where's your phone?
It's right in my phone.
Okay, tell me, I want to know the 3 lawyers that you talked to that I asked you to do.
It was the Jones. Technically, I talked to two.
Yeah, you're just mumbling.
But technically, I talked to 2 of the people at Donovan Jones.
You talked to 2 different lawyers there?
Yeah, I didn't realize that. One of the name was Matt Shanks. And the other one.
You actually went and visited with them?
Mr. Shanks.
Okay.
Cause remember, I don't live out here, so I couldn't.
Well, I don't remember. I
Oh,
do
I'm
this every
sorry, I'm
week
sorry.
with
No,
a
I don't-
courtroom that's full of.
I
Okay,
don't-
so you've talked on the phone with,
Yeah, yeah, and that's who I was mainly pretty much moving forward since I had talked to both of them.
okay,
We had they pretty much gave me basically a fair rate and stuff like that.
okay.
So
So when are you gonna get them hired?
um I want to say hopefully soon. Before
What is
the
that? I
end
don't know what that
of-
means.
by the 31st.
Okay,
July.
I'm gonna reset your case one more time. You need to get someone hired before that next court date. If it's not gonna work out with them or one of those people at Dunham and Jones, then you need to talk to at least 3 others and you need to have those names ready on who you actually spoke with when you come back, okay?
Okay.
And that's the takeaway from today's. Hearing courts often give people opportunities, but those opportunities come with expectations. Whether it's probation, treatment programs, or time to hire a lawyer. The real question is what someone does with the chance they're given.